Muy buenos días y vamos a dar inicio a la audiencia número 8 del 194 periodo de sesiones, que está titulada Repercusiones de la Ley de Libertad de Información en Guyana. Y doy una cordial bienvenida a representantes de la sociedad civil que el día de hoy nos acompañará en forma virtual. Lamentamos que no esté presente la ilustre representación del Estado de Guyana. Para efectos del acta, como suele suceder en este periodo de sesiones, de audiencias, se les ha realizado la invitación correspondiente, la cual pues lamentamos no haya tenido ninguna respuesta. Después de más de 2 años en que no teníamos un periodo de sesiones de audiencias públicas presenciales, estamos muy complacidos de celebrar este periodo de sesiones en la Universidad de Miami, lo que nos permite encontrarnos presencialmente con estudiantes y personas comprometidas con la defensa de los derechos humanos. En nuestra región persisten retos significativos para la plena vigencia de los derechos humanos y el fortalecimiento de la democracia, por lo que es fundamental seguir trabajando con firmeza y compromiso, de manera que podamos avanzar hacia sociedades más justas, libres e igualitarias. Antes de dar inicio a la audiencia, quisiera solicitar a las partes, en este caso a la sociedad civil, que puedan respetarse los tiempos de intervención que indicaré a continuación. Vamos a tener inicialmente 30 minutos para que de forma virtual podamos escuchar a los representantes de la sociedad civil. Posteriormente tendremos 30 minutos para que la comisión pueda hacer uso de la palabra. Después de que la comisión intervenga, vamos a darle 12 minutos adicionales a la sociedad civil y posteriormente tenemos la posibilidad de hacer ya el cierre de la reunión. Para asegurarnos que esta audiencia sea inclusiva, solicitamos a todas las personas participantes que inicien sus presentaciones indicando su nombre, su cargo y la organización o institución a la que representan. Posteriormente, cada vez que tomen la palabra, agradecemos que vuelvan a decir su nombre al inicio del mismo modo, ya que estas audiencias disponen de interpretación y de subtítulos a través de Zoom. Las personas que están en la sala pueden solicitar un dispositivo para la interpretación y quienes nos siguen virtualmente pueden encontrar el link de conexión en la página web de la CIDH. Conectándose a través de Zoom pueden elegir el idioma de audio y el tamaño de visualización de los subtítulos. El día de hoy también me acompañan en la mesa principal la comisionada Roberta Clark, el comisionado Carlos Bernal, el relator especial de libertad de expresión Pedro Vaca y nuestra especialista de la Secretaría Ejecutiva Fiorella Melzi. Sin más preámbulo, entonces, dejo en el uso de la palabra a la sociedad civil por un lapso de 30 minutos. Adelante, por favor.
If I may, because of the language issue, we're not quite clear as to what might have been said there, particularly in relation to inviting us to make our presentation. And I wonder if that could be clarified. Good morning, everybody.
Sí, tienen 30 minutos, por favor. Adelante.
Can I just thank you very much, Commissioner Rallon. Colleagues in civil society, the Zoom call has an interpretation button. An interpretation in English and Spanish is provided. So we will be speaking here in the Commission in both English and Spanish, and we encourage you to find the interpretation button and employ the English interpretation.
This one. Yes. CC. Let's see. Is that it? Click on. Yeah. It says English interpretation, yes, it does.
Y puede seleccionar en español para que pueda escucharme. Me confirma si puede escucharme, por favor.
You want to come on?
Yes, this is Vanda. I can hear you, interpreter.
Perfecto. Entonces vamos a dar inicio para que el tiempo que hemos tomado no corra. A partir de ahora, 30 minutos. Adelante, por favor.
Good morning. Please let me know when I can begin.
Sí, puede iniciar, por favor.
Thank you very much. Good morning, Mr. President, commissioners, representative of IACHR, and other persons present on the Zoom. My name is Christopher Ram, accountant and attorney at law, and member of civil society of Guyana. We would like to begin by thanking the IACHR to providing us this opportunity to address it on a concern which we, as members of civil society, have had for well over a decade. I will now begin my presentation. I appear before you today on behalf of a broad, committed, voluntary coalition of civil society organizations and individuals. Our coalition includes media workers, unionists, activists, and ordinary citizens, all united and committed by a shared interest in the rule of law, democratic participation, the right to truthful governance, and the right to access information governing our country. As a founding member of Transparency Institute of Guyana, Inc., TIGI, and as someone who made written submissions and appeared before the Parliamentary Select Committee during the consideration of the Access to Information Bill, I have long believed that transparency is not a luxury, but the lifeblood of accountable governance and democratic governance. Sadly, the promises of the law, which was passed in 2011, remains unfulfilled. Our country's constitution and its several obligations, including human rights treaties in the 4th schedule of the Constitution and the Escazú Agreement and the Access to Information Act 2011, provide citizens with rights to access to information. Those rights mean nothing if, as we have experienced, they are not respected by the state, despite all representation from civil society. Beginning in 2021, I have made multiple requests under the Access to Information Act. They were specific, lawful, and fully in accordance with the Act's requirements. Among other information, I sought a copy of the report of the circumstances leading up to the signing of the 2016 Petroleum Agreement, which is now a matter of international interest. Particulars of taxes paid on behalf of the oil companies under the said agreement. Information on the Guyana Online Academy of Learning, GOAL, a scholarship program initiated by the government of Guyana, for which we sought to get information. And finally, the administration and performance of the Commission of Information itself. Not once have I received a substantive response. In fact, many of the responses, so-called, are insults and disparaging comments about the persons requesting information. And in one particular case, the Commissioner of Information disrespectfully wrote, "Where ignorance is bliss, 'tis folly to be wise." Faced with official silence, I turned to the courts where the proceedings to seek the release of that information are pending. I have also written directly to the President of Guyana, not once, but on several occasions, informing him of the Commissioner's unexplained inaction and asked him to intervene to uphold the law. His Excellency's only acknowledgement was a casual remark at a public gathering. "I will look into your questions after the elections." Those elections have come and gone. The president has been returned to office, and still we are confronted with absolute silence, which constitutes a refusal to give us what we sought to receive. More recently, on October 21, 2025, ahead of today's hearing, I again wrote His Excellency seeking an update, hoping, perhaps against hope, to report some progress to this commission today. We have not even had the benefit of an acknowledgement, let alone a reply. But I wish to emphasize, Mr. President and Commissioners, that this is not a personal grievance. It seems to me and to us that this is nothing less than a civic and a democratic crisis. In the circumstances, I reached out to other members of our society, together with partners, the Transparency Institute, the Guyana Press Association, the Trade Union Movement, Red Thread Women's Group, and other individuals. We organized peaceful demonstrations, hoping to get responses. First, outside the Commissioner's office, where several such protest action failed to produce any results. As a result of which, we took the matter, having notified the President of our intention to do so. We took the matter outside the office of the President. Our only demand was that the law be implemented by the provision of the information which we sought. Despite at least 6 public engagements, we were not once invited, either by the Commissioner or by the Office of the President, to discuss the matter and our concerns. We can come to no conclusion but that the refusal to respond is not accidental, it is embedded. A commissioner has been in place since 2013, and we've never had, to the best of our knowledge, a single request for information met. Today, thanks to your kindness, 4 trusted colleagues will provide their own experiences regarding the Commission of Information to your respectful commission. The persons are Mr. Anand Gulsaran, a former Auditor General of Guyana, President of Transparency Institute Guyana, Inc., which is associated with Transparency International, and United Nations Executive Secretary of the Board of Auditors, and currently author of the weekly Accountability Watch column in the private sector-owned Stabroek News. That presentation will be made by Mr. G.H.K. Lal, because Mr. Gulsaran does not have electricity from where he is and is unable to join us. His presentation will be made by Mr. G.H.K. Lal. Then Ms. Danuta Radzik, environmental and human rights defender, who we have the pleasure with us today. The third person is Mr. Alfred Boulay, Professor Emeritus and long-standing transparency advocate and Director of Transparency Institute Guyana, Inc. And finally, Ms. Vanda Radzik, social justice and civil rights advocate, who participated and supported in every one of the public protests. Their collective experience reflects mine. We have each been systematically denied the exercise of a constitutional and internationally recognized right. International observers have noticed this too. The United Nations Human Rights Committee, electoral monitoring missions, editors and columnists in the national press have all remarked on the hollow state of Guyana's access to information system. They have noted that this absence undermines transparency, dilutes press freedom, corrodes public trust, and undermines our democratic process. We welcome in good faith the ruling party's 2025 election manifesto commitment to enforce the Access to Information Act, which we took as an admission, modest admission, of past inaction. Now, more than 12 years after an unproductive act and an inactive commissioner, credibility demands immediate and concrete steps following the manifesto commitment. These would include meeting all outstanding requests from all citizens, ending all legal obstacles, including court action or defending court action, and fully operationalizing and improving the Access to Information Act. Mr. Chairman, commissioners, and guests, we are not asking for special treatment. We only ask that our right to information is respected. In closing, I thank this distinguished commission for its attention, and with your kind permission, I now yield the floor to Mr. G.H.K. Lal to make his presentation on behalf of Mr. Anand Gulsaran. Mr. Lal.
Thank you, Mr. Ram. Good morning, Mr. President, commissioners, my fellow Guyanese on this call. I am GHK Lal, and I am reading the submission of Mr. Anand Gulsaran. I am a former Auditor General of Guyana, civil society activist, a transparency advocate, and a weekly columnist with the Stabroek News. On June 9th, 2014, in my capacity as the then president of the Transparency Institute Guyana Inc., TIGI, I submitted a request to the Office of the Commissioner of Information under Section 12 of the Access to Information Act that provides for the right of every Guyanese citizen or person domiciled in Guyana to obtain access to an official document. The specific request was for a copy of the contract between the Canadian software firm Free Balance and the government of Guyana for the implementation of a custom-built, automated, integrated financial management system, IFMAS, at the Ministry of Finance. The implementation of IFMAS began in 2004. However, two important modules, purchasing and asset and inventory, had not been activated up to the time of the letter. And as of September 2024, the position remained the same. 2 days later, on 11th of June 2014, TIGI received a rude, disrespectful, and arrogant response from the Office of the Commissioner, denying the request on the ground that the National Assembly had reduced the budget for the Office of the President, which reduction affected the Commissioner's office. I quote from the response as follows. As you are aware, and it is assumed that your acute concerns are national rather than partisan in nature, the budgetary allocations to this office have been excised from the estimates for 2014. Regrettably, therefore, your request, even if contemplated by the Act creating this office, cannot be considered until such time that retroactive approval is given for resources to be made available to this office. And in the closing paragraph, the Office of the Commissioner stated, in the words of the famous Calypsonian Mighty Sparrow, no money, no love. No doubt your institute, if at all influential, could ameliorate the disastrous consequences visited upon workers in general. A few days later, on 18th June 2014, the then Minister of Finance, with the approval of the Cabinet, began the process of restoring the original estimates for 2014 by withdrawing funds from the Consolidated Fund. It is relevant to note that in January 2017, I had written an article highlighting the shortcomings in the functioning of the Office of the Commission, for which I am facing a defamation lawsuit from the Commissioner. The matter is pending in the Guyana Court of Appeal. To date, after 12 years since the appointment of the Commissioner, the Commission has not responded positively to any request for information. That was Mr. Alan Gulsaran's statement. Thank you. The next speaker will be Ms. Danuta Radzik, Environmental and Human Rights Defender. Ms. Radzik.
Pleasant morning to the President and IACR commissioners. My fellow and Guyanese presenters and others on. I'm sorry, but the echo. I'm not sure why. Could that be?
Le escuchamos bien nosotros. Adelante. Nosotros le escuchamos bien.
Well, it's okay. Right. So my name is Danuta Radzik. I'm a human rights and environmental defender.
That already.
And this is my presentation. On October 22nd, 2025, a request made to Justice Charles R. Wilson, SC, OR, Commissioner of Information, for 10 documents, all related to Guyana's oil and gas industry. This request was made under Section 12.1 and Section 16.1 of the Access to Information Act 2011. The letter requested that documents be provided electronically, and if any was refused, to provide the legal basis for the refusal and details of the right to appeal. The letter thanked the Commissioner of Information for his cooperation and looked forward to a response at the Commissioner's earliest convenience. On October 24, a response was received from Justice Ramson, which acknowledged our application and assumed our eligibility to do so pursuant to Section 12 of the Access to Information Act 2011. However, Justice Ramson's response also indicated that the Office of the Commissioner of Information is not a public authority, contrary to some uninformed members, purportedly representatives, unelected civil society believe, and that if such documents become available, consideration will be duly given and appropriate action taken before any further correspondence is sent. Justice Ramson also recommended that in order to facilitate any further applications, we could access and consider his lecture sponsored by the Guyana Bar Association in 2017. His book, Metrics of the Bar Practices and the Bar Review. Requests for many of these same documents were previously made to the Environmental Protection Agency with no success. Based on the response from the Commissioner of Information, this request for information is once again at the dead end and calls into question the right of citizens of Guyana to access information, even though since 2011, the Access to Information Act has been in effect. We took special note of the Guyana Standard and Guyana Times newspapers article of August 19, 2025, which reported that according to the manifesto of the newly elected PPPC government, the Access to Information Act will be fully implemented. Unfortunately, this was not our experience, and we call on the relevant authorities, including the Office of the Commissioner of Information and all other agencies, to ensure that this request for information, as set out in the Access to Information Act, is followed and made available, and we, as well as others who may have been denied access to documents and information, receive these as our right under Guyana's Access to Information Act 2011. Thank you. That is my presentation. And if wished, I could later, I could provide the names of all the documents that I requested. Thank you.
Thank you, Danuta. Again, Mr. G.H.K. Lal will now read a statement by Mr. Alfred Bulai. And in addition, because of the additional time that we do have, Mr. Chairman, Mr. Lal, who is an active member of our committee, will also be making a statement on his own behalf. Mr. Lal.
Thank you again, Mr. Ram. The statement from Mr. Alfred Bulai, Mr. President, Commissioners, fellow Guyanese on this call. Mr. Bulai has been a long-standing and outstanding member of in the educational field of Guyana. He has been a man very deeply immersed in Roman Catholic Church activities. He has been a civil society activist on a number of issues, a founder of the Astronomical Society of Guyana, a member of the Transparency Institute Guyana, Inc. Mr. Bulai is a superb citizen of this country. I represented TIGI at a Zoom meeting with the top brass of ExxonMobil Guyana Limited on February 12, 2021. I asked too many questions during the limited time for them in the 1 hour meeting, to which the local president said I should follow up by asking the government to provide the information that I was seeking. I took his advice after the promised recording of the meeting never materialized and asked the Ministry of Natural Resources, copied to the Environmental Protection Agency on March 26, 2021. After waiting over a year for a response, I reluctantly decided to use the Access to Information Act, which I long recognized depended on gaining the grace and favor of the Commissioner of Information. In the third decade of the 21st century, there was no online presence for this office, not even an email address. After visiting his office, which is actually his home, since government saw it fit not to provide him with staff and office space, the Commissioner of Information decreed that the Commissioner is available on weekdays between 7 and 10 a.m. at a certain telephone number and for consultation. I was received cordially and was advised to read the official gazette and a presentation he made to the Guyana Bar Association in one of its review journals. I found and I read them. Then I followed all the instructions and protocols scrupulously and submitted my request. I received an acknowledgement the next day by courier. 30 days passed, and I received no reply, nor reason for no reply. 60 days passed, and according to Section 18 of that dastardly Access to Information Act, if by then no information becomes available, then the information is deemed to be inaccessible. QED. Like it or lump it. There is no punishment or remedy in the legislation applicable to the Commissioner of Information for not doing the job, even though what is clearly occurring is a blatant dereliction of duty by this public servant paid from the public purse to implement the act. That was the submission from Mr. Alfred Bulai. I've been asked to continue and speak on my own behalf as a member of this committee,
Voy
this
a
civil society
interrumpirlo un
advocate
momento,
movement.
disculpe. Voy
Yes,
a
sí,
interrumpirlo un momento por razones de tiempo. Va a tener oportunidad después de la comisión todavía de un lapso de 12 minutos para el otro testimonio o alguna petición a la comisión. Pero siguiendo con la agenda de la audiencia, voy a pasar ahora a darle la palabra a la comisión, quien tendrá algunas preguntas. Inicialmente, la comisionada Roberta Clark.
Thank you very much.
Excuse me, please. I am Vanda Radzik, and I am part of the presentation. I don't know why it has taken already 30 minutes, but I am now once again denied to make the concluding remarks, which has the 3 asks to the commission.
Señora Radzik, al inicio de la audiencia establecimos la agenda y van a tener 12 minutos todavía para hablar. Corresponde ahora a la comisión hacer preguntas, así que agradeceré puedan también escuchar las preguntas de la comisión y luego les voy a devolver la palabra. Comisionada Clark, por favor.
Thank you very much, Commissioner Alon, and colleagues, civil society organizations in Guyana. I think that there will be time for another round of submissions. I just wanted to say as we start off that I do regret that the state is not here with us. And I would like to just maybe recount the authority under which this hearing is being held. And it is being held pursuant to the rules of procedure of the Inter-American Commission of Human Rights, in particular under Chapter 6, which provides the guidelines or the directives for hearings before the Commission. And I wish to draw your attention to Article 59, which indicates that hearings can be held at the initiative of the Commission, what we call ex officio hearings, but they can also be held at the request of an interested party. And the purpose for these hearings are to receive information, and we can receive information in relation to petitions or cases being processed, which is not the case here. And we can also receive information in regard to follow-up to recommendations, which is not the case here. Precautionary measures, not the case here. Or, and I quote, general or particular information related to human rights in one or more member states of the OAS. And what I understand here is that the issue concerns the freedom of expression under Article 13 of the American Convention on Human Rights. I want to say specifically, this is not a hearing under the petitions and cases system, but rather a hearing of a quote-unquote general nature, which is outlined in Article 64 of the Rules of Procedure. So persons who are interested in presenting testimony or information to the Commission on the Human Rights situation in one or more states or on matters of general interest shall direct a request for a hearing to the Executive Secretariat with proper notice prior to the respective session. And it is in that context that we're having a hearing of a general nature concerning the Article 13, I think, more specifically. So having set out the context within which this hearing is occurring, I also wish to say that Article 13, and we will hear more about that from our Special Rapporteur on Freedom of Expression, speaks to freedom of expression, but also the right to receive information. And I also wish to recall, as the rapporteur, the country rapporteur for Guyana, that the Inter-American Democratic Charter under Article 4 also requires member states of the OAS to engage in transparency in government activities. So it's in that context I acknowledge the request for this hearing, and also now I will ask a few questions. In all of the presentations that were presented this morning, we are hearing a pattern of, I would say, complaint of a non-responsive office of the Commissioner on Information, non-response generally, or delays in response, or maybe even I would say, well, let me leave it at that. We also heard a bit about whether or not the office of the Commissioner is adequately resourced to do the task that is required of that office. And in that context, I have one or two questions that I wish to ask you, those who are here. First of all, under the relevant legislation, I think it's the 2011 legislation, where the office, the Office of the Commissioner of Information is established. I would like to find out, under that legislation, are there provisions for appeals from decisions of that Office of the Commission? And are those appeals encased within the legislation? Like, is it an administrative appeal, or does one have to go to the contentious jurisdiction of the High Court to review decisions of the Office of the Commissioner? Secondly, are there routinized annual moments where the Office of the Commissioner is obligated to present information to the Parliament and or to the Executive on the performance of that office, on the number of requests for information received, and on compliance, on a status report on compliance with the request? In other words, is there a performance review of the functioning of the office, which is part of a routine requirement of the legislation? And then I think the last speaker referenced the fact that the Commissioner may be functioning out of their own homes. I'm not sure if I heard that correctly, but I would like, if you have that information, to understand better the resourcing to this very important mechanism as it stands now. Thank you very much.
Muchas gracias, comisionado Bernal.
Good morning, everyone. I would also like to thank the petitioners for being willing to give their views in this hearing. And I just have a couple of questions, one procedural and one substantive. The procedural one is, I would like to know if the petitioners have litigated these issues internally. And if that is the case, if they can report what the court have ruled domestically about this matter, and if it is not the case, then I would like to know why they haven't litigated this point internally. And then my substantive question is, what would be the remedies that they could envision? And I mean not individual remedies, but more structural remedies that can benefit the satisfaction of the right to access to information in Guyana. Thank you so much.
Muchas gracias. El relator especial de libertad de expresión.
Muchas gracias, Presidente Ralón. First of all, I would like to thank the information provided, and always when we have states that do not attend to hearings, I always have the hope that as these hearings are public, the information that is shared here could be understood in the good faith with our open hands to keep the conversation ongoing. So I'm glad to know that this conversation is public because of that. Probably, I think that my role here is to start by saying that access to information is one of the basic conditions that allows democracy to function. It is what enables people to understand how decisions are made, to evaluate the actions of their authorities, and to participate meaningfully in public life. Without access to timely, reliable, and complete information, democratic debates weakens, oversight becomes difficult, and public trust could be eroded. It is from the perspective that the Inter-American system has consistently recognized the right to access to information as a fundamental guarantee for transparency, accountability, and good public administration. I want to acknowledge in this hearing that Guyana has a starting point in this regard. The Access to Information Act of 2011 established a legal framework that, on paper, incorporates many of the foundational elements of a modern transparency regime. 14 years later, this hearing offers an important opportunity to reflect on whether this framework remains adequate for the needs of the country today, and most importantly, whether the law has been effectively implemented in practice. During this hearing, we have taken careful note of the concerns expressed by the civil society. The perspectives we have heard are so far and are essential to understanding how the law is operating in practice and where challenges exist. At the same time, it is key to hear the state's own assessment on the current state of the Access to Information law, how it is functioning, what obstacles have emerged, and what measures are being taken to ensure its full implementation. This balance of perspectives is a central part of the Commission's and our office independent and impartial methodology, which requires listening to all actors, contrasting the information received, and promoting an informed and constructive dialogue. I now would like to recall the Inter-American standards regarding access to information, which require the legal mechanism for requesting information be simple, accessible, and effective. This also includes, for example, minimal formal requirements, low or no cost, firm deadlines for responses, the possibility for oral requests in certain circumstances, an obligation for authorities to assist petitioners, and the availability of appeals, as was shared by Commissioner Clark, before an autonomous body and eventually before the judiciary. I also wish to recall that adopting an access to information law is only the first step. Implementation requires a clear, adequately founded plan to progressively achieve the full realization of the right, a proper system and systems and practices for the creation, preservation, and administration of public information, and a comprehensive training programs for officials responsible for records management and responding to requests. On the interest of time, President Ralón, of this hearing, I ask that you could, the petitioners, if you could move forward with your presentation, as it was interrupted because of time, and also to invite you to submit, if you consider, written inputs for the Commission and for my office. I would like to wrap up with a short reflection. Who's the owner of the public interest information? I think it's the people, and that's something that is horizontal, interesting and important for all actors in society. And that's why also the Inter-American system has brought the attention of public interest information, as it could be, for example, the information regarding extractive industries. We have at the Inter-American Commission on Human Rights a guide on access to information in this field. I think the Inter-American system has a lot of tools to be shared to improve the discussion inspired in the Inter-American experience. Thank you, President Ralón.
Muchas gracias, relator. Yo quisiera también agradecer las presentaciones y reconocer el trabajo de la sociedad civil para mantener este tema en la agenda pública. Uno de los objetivos de estas audiencias es poder generar un canal de diálogo entre la sociedad civil y el Estado. Yo tengo varias preguntas, pero la primera es si existe algún canal de diálogo, alguna forma en la cual como organizaciones ustedes puedan conversar sobre este tema con el Estado. Esa sería la primera pregunta. La segunda pregunta es cuáles son los criterios para elegir y nombrar al comisionado encargado de acceso a la información en Guyana. Y la tercera pregunta es si independientemente de las solicitudes de información hay algún tipo de informe anual o un reporte global que la Oficina de Información presente con alguna periodicidad en Guyana. Esas serían las preguntas. Vamos a, digamos, detener acá la participación de la comisión y ustedes van a tener hasta un tiempo de 25 minutos para que puedan terminar sus testimonios y para que puedan hacer sus peticiones. Si esos 25 minutos no son suficientes para responder las preguntas, pueden ustedes mandarnos por escrito las respuestas de las preguntas, ya que han sido varias. Así que vamos a dar 25 minutos para que puedan terminar el testimonio, hacer sus peticiones y responder las preguntas que ustedes consideren, mandando por escrito las que no den tiempo. Muchas gracias. Así que pasamos a esa última parte y a partir de ahora les devuelvo la palabra por 25 minutos.
I would like, this is Vander Radcliffe. I would like to complete, if that is possible.
Sí, adelante, por favor. Sí, la escuchamos, señora Banda. Por favor, adelante.
Go ahead, Vanda.
I'm looking for the presentation, having been interrupted. I don't know if I can find it again. Jesus. Please bear with me. I'm trying to bring up my very short concluding remarks. I'm just trying to locate it. Okay, I'm Radcliffe, social justice, rule of law advocate. So to conclude the original presentation, I just wanted to reiterate that there was a broad and inclusive swath of civil society that engaged in peaceful public protests over a 2-month period outside both the offices, which is also the home of the Commission of Information and the Office of the President over a 2-month period. And it included a number of organizations that Chris has already mentioned, including trade union leaders, attorneys of law, the Guyana Press Association, and women-led NGOs, as well as indigenous organizations. Article 14 of the Guyana Constitution enshrines an inclusionary democracy in which citizens and their groups are entitled to participate in the political, economic, and social decision-making processes of the state. But as Norris Pitcher, president of the Guyana Workers' Union, eloquently said elsewhere, quote, "How can we fully participate in making informed decisions if we are denied basic right to such public information?" Madam President, and commissioners, what we bring you today is not an abstract concern. It is a lived experience of a right denied persistently, deliberately, and systematically. We respectfully ask the Commission to, 1, urge the state of Guyana to bring its practice into conformity with the Access to Information Act, our Guyana Constitution, and its binding international obligations. 2, call upon the Commissioner of Information to fulfill his duties under the law, to receive, process, and respond to requests in a timely, lawful manner. 3, recommend concrete measures to guarantee the independence, functionality, and accountability of the entire access to information mechanism. We thank you.
Thank you, Vanda. Mr. President, do I have a few minutes to respond to the specific questions that have been asked by honorable commissioners?
Sí, por favor, te está corriendo el tiempo, tiene todavía varios minutos hasta las 10:19 hora de Miami.
Now, the first question that I have was the appellate procedures. Under Section 43 of the Access to Information Act, aggrieved persons may apply to the High Court for review of decisions by way of judicial review. In my particular case, such actions have been taken and the matters are pending before the High Court. So yes, we have availed ourselves of the legislation, but it's straight from the Commissioner of Information to the court. There is no ombudsman, there's no other mechanism that could shorten the process and make it less effective. The second question is whether there was any information on a performance review. Section 44 of the Act requires the minister, as soon as practicable, but not later than 9 months after the end of each year, to lay a report on the operation of this Act in the National Assembly. No such report, based on public information, no such report has ever been tabled in the National Assembly. And as our member, Mr. Gulsaran, said, in raising an issue about such a report, he has found himself on the wrong end of a defamation action by the Commissioner of Information. So that I have also applied there the litigated the remedies we have sought, simply to ask for the information to be provided. The Commissioner in each case has challenged our right, and the court is yet to make a decision. In terms of remedies, all we have asked for is that the information we sought under Section 12 of the Access to Information Act be provided in accordance with the requirements of the Act and, of course, the Constitution and the and other conventions to which we are part. So there are no other mechanisms. We have tried, I've asked, we've written the president, we've asked for an opportunity to have a meeting. There has been none. So there is no remedy available to us, formal or informal, other than through the court. Those are our specific questions, so the answers that have been raised, which are all very relevant. But they go to the point that no information has been provided. The Act has essentially not been operationalized. And by its own admission, the government in its 2025 manifesto has undertaken to operationalize the act. There has been no indication if and when what should have been done for 14 years, whether it will ever be done. Those are my responses, and we can provide formal written responses to your commission following these hearings. I thank you.
Commissioners,
I have,
I would like to respond. I would like to say
I have,
that the fact that the Commissioner of Information or the state has not turned up at the invitation of the OAS IACHR speaks volumes. It is unresponsive, Commissioner of Information, unresponsive even to you. And so is state as a whole unresponsive to you, IACHR, on this matter of public information. Thank you.
if I could say, I would also like to raise two things. One is that as far as we are aware, the Office of the Commissioner of Information is at the personal home of the Commissioner of Information. When we delivered our letter requesting 10 documents, what happened is the commissioner looked out of his window and told us to put our letter or document into the mailbox. We were not even aware that there was a clerk or somebody else in that office who could have come down or even appeared at the window and, to tell us how the document would be received. So that is one thing. Secondly, I would like to say that when we received the reply from the Commissioner of Information, and he said that he was not a public authority and referred to Section 2 of the Act, a reading of that section made no sense. It did not refer to the fact that, the Commissioner of Information is not empowered, right, to request from any public authority documents, because that is the basis of the Act. I wanted to raise those things. I think there was a last question. Oh yes, on reports to Parliament. As far as we know, the Commissioner of Information has never put a report to the Parliament of Guyana on the activities of the Commissioner of Information as regards the Access to Information Act. And as Mr. Gulsaran mentioned, adequate money is available, has been made available to that office to ensure that reports and the functioning of the office should be implemented. And we have heard a figure of 40 million Guyana dollars being allocated to do that. But other members here might also be able to speak to these matters. Thank you.
Muy bien, muchas gracias. Entiendo que ha terminado la presentación de la sociedad civil y quedamos muy pendientes de cualquier respuesta que nos quisieran hacer llegar ustedes por escrito. Ha sido una oportunidad para que la comisión pueda recibir detalles importantes de cómo está la situación de acceso a la información en Guyana. Así que, habiendo cumplido con la agenda, agradecerles a la sociedad civil y doy por cerrada la presente audiencia. Muchas gracias.